Case 1, Crystina Schroer, November 2025, Sedgwick County District Court, Kansas. In the quiet rural community of Rose Hill, Kansas, a small town of just over 4,000 people situated in the southern reaches of Sedgwick County, neighbors described their streets as the kind of place where families knew each other, where children played in front yards without fear, and where the idea of danger felt distant. Rose Hill was the kind of community that trusted itself. That trust, as investigators would later discover, had been exploited in the most devastating way imaginable, not by a stranger, not by someone lurking in the shadows, but by a woman who had been trusted with the most sacred responsibility a person can hold: the responsibility of being a mother. Crystina Schroer appeared, on the surface, to be exactly what the system had hoped she would be. She had opened her home to children in the foster care network. She had signed the paperwork, passed the background evaluations, and presented herself as a caregiver willing to provide stability to children who needed it most. Among those children was a little girl who went by the name Kennedy, a name her family and those who loved her had given her, a name that carried warmth and identity and belonging. Her legal name was Natalie Garcia. She was 6 years old. What happened inside that home in Rose Hill over the course of late 2020 would not come to light for nearly 4 years. For 4 years, the community did not know. The authorities did not know. The child welfare system did not know. And that gap, that silence spanning nearly half a decade, is one of the most disturbing elements of a case that already defies comprehension. To understand what investigators eventually uncovered, it is necessary to go back to the fall of 2020. Kennedy, as she was known to those who cared for her, had been living in Schroer's home as a foster child. The details that emerged during prosecution paint a picture of a household where discipline had crossed every conceivable boundary, where punishment had transformed into something the court system, the child welfare community, and investigators would later describe as a profound failure to protect a vulnerable child. According to court documents filed in Sedgwick County District Court, Kennedy lost her life in November of 2020. She was 6 years old. The manner of her passing, as established through the subsequent legal proceedings, involved confinement inside a reinforced box, a structure that prosecutors argued had been used as a form of punishment within the home. The child did not survive that confinement. She suffocated. She was 6 years old, and she was alone, and she did not survive. What followed her passing was not grief shared with the community, not a call to emergency services, not an attempt to seek help or account for what had happened. What followed was concealment. Crystina Schroer, according to the evidence presented in her case, buried Kennedy's remains in the backyard of the property. And then she went on with her life. For 4 years. Consider the weight of that number. For years, Kennedy would have turned 7, then 8, then 9, then 10. The world moved forward, seasons changed across the Kansas plains, and a little girl who had deserved every possible protection that society could offer lay in an unmarked place behind a house in Rose Hill, while the system that had been responsible for her safety remained unaware. The investigation that eventually brought this case to the attention of law enforcement began not through a routine welfare check or a tip from the community, but through the slow unraveling of information that, once it began to surface, could not be contained. Kansas law enforcement, working in coordination with child welfare investigators, received information in 2024 that prompted a serious examination of what had occurred inside the Schroer household. What they discovered when they began to dig, both figuratively and literally, would shock even the most seasoned professionals in Sedgwick County. Kennedy's remains were located on the property. The forensic investigation that followed, conducted with the kind of methodical precision that serious criminal cases demand, worked to establish the timeline, the cause of harm, and the circumstances surrounding the child's passing. Investigators documented evidence consistent with the manner of harm described in the prosecution's account: confinement in a reinforced structure used as punishment. The child had been in the care of someone who had been vetted and trusted by the state of Kansas, and she had not survived that care. Crystina Schroer was taken into custody. The charges filed against her in Sedgwick County District Court reflected the gravity of what had occurred: second-degree murder and child abuse. These were not charges filed lightly. They represented the considered judgment of prosecutors who had reviewed the evidence, understood the timeline, and made the determination that what had happened to Kennedy in that Rose Hill home was a criminal act for which accountability was not only appropriate, but essential. The legal proceedings that followed moved through the Kansas court system with the careful deliberation that cases of this nature require. Schroer's defense team engaged with the prosecution, and in August of 2025, Crystina Schroer entered a plea of no contest to the charges of second-degree murder and child abuse. A no-contest plea, under Kansas law, carries the same legal weight as a guilty plea in terms of criminal consequences. The court proceeds to sentencing on the basis that the evidence supports the charges, even if the defendant does not formally admit guilt in words. In practical terms, Schroer accepted the legal consequences of what had happened to Kennedy without mounting a full contested trial. Sentencing was scheduled and held in November of 2025, almost exactly 5 years after the month in which Kennedy had lost her life. Sedgwick County District Court handed down a sentence of 215 months in the Kansas Department of Corrections. That is 17 years and 11 months, the better part of 2 decades. The sentence was significant. It was also, for many in the child advocacy community in Kansas, a statement that the courts understood the magnitude of what had occurred, not just the harm done to one child, but the 4 years of concealment that had compounded that harm and denied Kennedy even the dignity of being found. The case of Crystina Schroer has since become a reference point in Kansas child welfare discussions. The fact that a child could be harmed in a licensed foster placement, that her absence could go undetected for 4 years, and that her remains could lie undiscovered for that long despite the existence of a child welfare monitoring system. These are questions that the state of Kansas has had to confront directly. Child welfare advocates in Kansas and nationally have pointed to this case as evidence of the critical need for more rigorous, more frequent, and more substantive contact between welfare workers and children in foster placements. Not just paperwork reviews, but real, in-person assessments that ensure each child is safe, present, and thriving. Kennedy was 6 years old. She had a name she loved, one given to her by people who cared about her. She was a child in the foster care system, which means she had already navigated more instability and uncertainty than most children ever face. She deserved protection. She deserved safety. She deserved a future. The Kansas court system, through its verdict and its sentence, affirmed that what happened to her was wrong, that it was criminal, and that it would be answered for. Crystina Schroer is currently serving her sentence of 215 months in the Kansas Department of Corrections. The case remains a sobering chapter in Sedgwick County's history, a reminder of what is at stake when the systems designed to protect the most vulnerable among us fail in their most fundamental duty. If you or someone you know has concerns about the safety or welfare of a child, the Child Help National Child Abuse Hotline is available 24 hours a day, 7 days a week, at 1-800-422-4453. Reporting a concern can save a life. Kennedy deserved better. The court's verdict ensures that her story and the accountability that followed will not be forgotten. If this case has moved you, please take a moment to like this video and subscribe to Cold Case Hour. Your support helps us continue bringing these important stories to light. Case 2, Mariann Belair, August 2024, Shawnee County District Court, Kansas. Topeka, Kansas is the state capital, a city of nearly 125,000 people, home to the Kansas State Capitol building, to institutions of government and law, to neighborhoods of every kind spread across the rolling landscape of Shawnee County. It is a city with a serious and professional law enforcement community, a well-developed court system, and prosecutors who have handled some of the most complex criminal cases in the state's history. And yet, even in Topeka, even in a city familiar with the full spectrum of human behavior, the events of October 23, 2023 produced a response from investigators, prosecutors, and community members that could only be described as heartbreak. Belair was 4 years old. She was the kind of child whose age alone, 4, carries a particular weight in the imagination. 4-year-olds are curious and loud and full of questions. They are learning the names of things and discovering the rules of the world and testing every boundary they encounter. They are, in almost every meaningful sense, completely dependent on the adults around them for their safety. They cannot make the decisions that protect them. They rely entirely on the judgment, the attention, and the responsibility of the grown-ups in their lives. On October 23, 2023, That responsibility failed Laurencia in a way that was both preventable and permanent. According to the evidence presented at trial in Shawnee County District Court, Mariann Belair, Laurencia's mother, had a loaded 9mm handgun accessible in the family's home. The firearm was not secured. It was not locked in a case or stored in a manner that would prevent access by the children in the household. Court records and testimony established that on that October afternoon, the loaded firearm was left on a couch, unsecured, within reach, in a living space where young children were present. For a period that prosecutors established to be at least 12 minutes, Belair was distracted by her mobile phone. 12 minutes. In the context of adult time, 12 minutes is not very long. It is a short meeting, a brief phone call, a commercial break during a television program. In the context of child safety, 12 minutes with an unsecured loaded firearm in the home of a 2-year-old and a 4-year-old is an eternity. Laurencia's 2-year-old brother found the firearm. A 2-year-old child, unaware of what the object was or what it could do, picked it up. The gun discharged. Laurencia Belair, 4 years old, did not survive the injury. Emergency services responded to the home. What they found was a tragedy that never needed to happen. A child's life ended not by any external threat, not by any force that could not have been anticipated or prevented, but by a combination of factors entirely within the control of the adult responsible for those children's safety. The firearm should not have been accessible to the children. The supervision should not have lapsed. The 12 minutes of distraction should not have occurred in circumstances that made it deadly. Mariann Belair was arrested. The charges filed against her in Shawnee County District Court were serious: first-degree felony murder and aggravated child endangerment. Under Kansas law, felony murder in this context means that a death resulted from the commission of an underlying felony, in this case, child endangerment. The prosecution's argument was clear and structured. Belair had endangered her children by leaving a loaded firearm accessible. That endangerment was a felony, and Laurencia's passing was the direct result of that felony. The law did not require intent to harm. It required only that the endangerment occurred and that the tragedy followed from it. The trial proceeded in Shawnee County. The evidence was methodically presented: the timeline of the afternoon, the position of the firearm, the duration of the lapse in supervision, the circumstances that led to a 2-year-old accessing a loaded 9mm handgun in the family living room. On the 29th of May, 2024, the jury returned its verdict. Mariann Belair was found guilty of first-degree felony murder and aggravated child endangerment. The community response to the verdict in Topeka was significant. Child safety advocates, legal professionals, and community members who had followed the case understood that the verdict sent a message that in Kansas, the failure to secure a firearm in a household with young children, resulting in the loss of a child's life, would be treated by the courts with the full weight of the law. This was not a case of ambiguous circumstances or contested facts. This was a case where the adult responsible for these children had made a choice, or rather, had failed to make the choice. That cost Laurencia her life. Sentencing was held in August of 2024 in Shawnee County District Court. The judge handed down a sentence of life in prison, with no possibility of parole for 25 years. An additional 6 months was added for the aggravated child endangerment conviction. Mariann Belair, as of the date of sentencing, faced the prospect of spending at minimum 25 years in the Kansas Department of Corrections before she would be eligible to ask a parole board for release. The sentence drew commentary from child safety organizations across Kansas and nationally. The Brady Campaign, which advocates for responsible gun legislation and the prevention of firearm-related harm to children, has consistently documented the devastating consequences of unsecured firearms in homes with children. The case of Laurencia Belair became part of that documentation, a real, named, 4-year-old child whose story illustrates in the most painful possible terms what the data about child firearm injuries represents in human terms. Laurencia was 4 years old. She had her whole life ahead of her. The Kansas courts, in their verdict and their sentence, affirmed that her life had value, that the failure to protect her was a serious crime, and that accountability was not optional. For any family with firearms in the home, the message from this case could not be more direct or more urgent. Secure your firearms. Lock them. Keep them unloaded. Store ammunition separately. Use trigger locks. These are not suggestions. They are the difference between a life protected and a life lost. The Kansas courts have made clear that in this state, the failure to take those precautions, when it results in harm to a child, will be answered for in a court of law. Mariann Belair is currently serving her sentence in the Kansas Department of Corrections. Laurencia Belair was 4 years old. Her name deserves to be remembered, not only as a victim, but as a reason why responsible firearm storage in homes with children is not a political question. It is a matter of life. If this case has stayed with you, please like this video and subscribe to Cold Case Hour. We tell these stories so that lives like Laurencia's are never forgotten. Case 3. Heather Jones, February 25, 2016, Wyandotte County District Court, Kansas. There are cases in the history of American true crime journalism that have forced the institutions surrounding them, child welfare systems, school districts, law enforcement agencies, neighbors, and communities, to engage in a serious and sustained reckoning with the question of how. How did this happen? How did it continue? How did no one know? The case that emerged from a property in Kansas City, Kansas in October of 2015 is one of those cases. It is a case that shook Wyandotte County to its foundation, drew national attention, prompted legislative review of the Kansas child welfare system, and placed the name of a 7-year-old boy, Adyson Jones, permanently in the consciousness of everyone who heard it. To tell this story accurately and responsibly, it is necessary to begin not with the events of 2015, but with the years that preceded them, because what happened to Adyson Jones was not a sudden event. It was a prolonged process, and that process unfolded in a household that had contact with schools, with social services, and with extended family members over a period of years. The fact that it continued for as long as it did is not only a story about individual culpability. It is a story about systemic failure on a scale that the state of Kansas has since worked, imperfectly and painfully, to address. Adyson Jones was born in 2008. He came into the world in the same way all children do, dependent, vulnerable, and entirely reliant on the adults responsible for his care. His early years were marked by instability, and at some point during his childhood he came to live with his biological father, Michael Jones, and his stepmother, Heather Jones, at a property in Kansas City, Kansas. The household also included other children. What investigators, prosecutors, and the Wyandotte County courts would later establish through the criminal proceedings against both Michael Jones and Heather Jones was that the conditions inside that household were profoundly dangerous for Adyson. The child was subjected to a pattern of severe mistreatment and deprivation over an extended period of time. Court records and the testimony of investigators describe a child who was denied adequate nutrition, who was subjected to conditions of extreme hardship, and who suffered physical harm at the hands of the adults who were responsible for his welfare. Adyson Jones lost his life in 2015. He was 7 years old. The discovery of what had happened came in October of 2015 when law enforcement was called to the property. What investigators found there, specifically, the condition of a structure on the property and the evidence recovered from it, prompted an immediate and intensive investigation by the Kansas Police Department working in coordination with Wyandotte County prosecutors. Adyson's remains were found on the property, in a location that shocked even experienced investigators. The case was immediately elevated to the highest priority, and the investigation that followed was one of the most thorough and emotionally taxing that the Wyandotte County law enforcement community had undertaken in years. Both Michael Jones and Heather Jones were taken into custody. The case against Heather Jones, Adyson's stepmother, proceeded through Wyandotte County District Court. She was charged with first-degree murder and child abuse. The evidence assembled by prosecutors was extensive. It included the physical condition of the property and the circumstances of Adyson's passing, testimony from individuals who had had contact with the household, and records that documented a pattern of behavior extending over time. The prosecution's case established that the harm Adyson experienced was not incidental or accidental. It was sustained, it was severe, and it had continued over a period long enough that the child had been profoundly affected by the time investigators arrived. On February 25, 2016, Heather Jones entered a plea of guilty to first-degree murder and child abuse in Wyandotte County District Court. The plea represented a full acknowledgement, in legal terms, of her responsibility for what had happened to Adyson Jones. Sentencing followed. The Wyandotte County District Court imposed a sentence of life in prison, with the possibility of parole after 25 years for the first-degree murder conviction. An additional sentence of 5 years and 8 months was imposed for the child abuse conviction, to be served consecutively. The total sentencing package reflected the court's assessment that what had been done to Adrian Jones over the course of his short life demanded a serious and sustained accounting. The case had an impact that extended far beyond the Wyandotte County courtroom. In Kansas City and across the state, the story of Adrian Jones prompted an immediate examination of the child welfare systems that should have identified and intervened in his situation long before October of 2015. How had a child in contact with public systems, school enrollment records, welfare contacts, neighborhood awareness, been harmed so severely and for so long without intervention? The Kansas Department for Children and Families faced serious scrutiny. Advocacy organizations called for reforms in the way welfare workers document and follow up on children flagged as at risk. Kansas legislators introduced, and in some cases passed, changes to the child welfare statutes intended to strengthen oversight and accountability. The name Adrian Jones became, in Kansas, a reference point, a name spoken in legislative chambers and child welfare training sessions and community meetings as a reminder of what the system is supposed to prevent and what happens when it does not. His story is part of the public record, part of the history of how Kansas child welfare policy developed in the years following 2015, and part of the reason why thousands of professionals across the state take their responsibilities more seriously today than they did the morning before his case was known. Heather Jones is serving her life sentence in the Kansas Department of Corrections. She will not be eligible for parole consideration until she has served 25 years. Michael Jones received separate sentencing in his own proceedings for his role in what happened to Adrian. Adrian Jones was 7 years old. He liked to play. He had favorite things, the small preferences and enthusiasms of a little boy, that the world will never fully know because his story was cut short before it had the chance to be fully told. What the record does tell us is that he deserved protection, that the systems around him failed in that duty, and that the courts of Wyandotte County, Kansas, in the winter of 2016, made certain that accountability followed. If you are a mandated reporter or a community member with concerns about a child's safety, please do not hesitate to contact the Kansas Protection Report Center at 1-800-922-5330. The call you make could be the intervention that changes everything. Adrian deserved better. His name will not be forgotten here. Please like this video and subscribe to Cold Case Hour. These stories matter. Sharing them is how we honor the lives of the children at their center. Case 4, Liberti in Figueroa, October 2025, Leavenworth County District Court, Kansas. Not every case that reaches a Kansas courtroom involves premeditation or deliberate malice. Not every case that results in criminal conviction involves a defendant who set out to cause harm. Some of the cases that child welfare prosecutors and Leavenworth County District Court judges have had to confront involve something different, something more complicated, and, in its own way, more troubling. They involve the complete absence of the attentiveness, the urgency, and the instinct that a young child's vulnerability demands. They involve a failure not of intention but of presence, a mother who was there in body but absent in every way that mattered when it mattered most. The case of Liberti in Figueroa and the death of her 18-month-old daughter, Serafina, falls into this category. It is a case that Leavenworth County prosecutors brought to trial not on the theory that Figueroa intended harm, but on the theory that her failure to exercise the care a parent owes a very young child, an 18-month-old, a baby, constituted criminal endangerment that resulted in that child's death. The jury's verdict, returned in August of 2025, reflected the complexity of that legal question. Serafina Figueroa was 18 months old in 2023. 18 months is barely past infancy. A child at this age is walking with the unsteady confidence of recent discovery, beginning to form words, entirely dependent on caregivers for safety and supervision. An 18-month-old cannot communicate danger, cannot call for help, cannot recognize risk. An 18-month-old child is, in the most direct and unambiguous sense, in need of consistent, attentive care. According to the evidence presented at trial in Leavenworth County District Court, Liberti Figueroa made the decision to leave Serafina in the care of a boyfriend, a man who prosecutors described during the proceedings as an irresponsible caregiver someone Figueroa had reason to know was not a suitable person to be solely responsible for an 18-month-old child. The specific concerns about this individual's reliability and judgment were, according to the prosecution, known to Figueroa or should have been known to her. Despite this, Figueroa left Serafina with him. During the period when Serafina was in this person's care, the child sustained head trauma. The injuries were severe. When the situation became apparent and Serafina received medical attention, the damage was not survivable. The child did not live. The prosecution's case against Figueroa in Leavenworth County focused on what Figueroa had done and what she had failed to do in the hours surrounding the time of Serafina's injury. Court records established that during this period, Figueroa was not present with her daughter. She was elsewhere, and according to the evidence presented, she was engaged in activities, including substance use, rather than checking on a very young child in the care of someone who should not have been entrusted with that responsibility. The specific timeline established through investigation and testimony showed that Figueroa had not checked on Serafina for a significant period of hours. For an 18-month-old child, hours of unmonitored care with an inadequate caregiver is not simply a lapse in judgment. Prosecutors argued it represented an active, conscious abandonment of the protective duty that Kansas law and basic human responsibility places on a parent. Figueroa was charged with involuntary manslaughter and 2 counts of aggravated child endangerment. The trial proceeded through Leavenworth County District Court in the summer of 2025. The verdict, returned on the 28th of August, 2025, reflected the jury's careful navigation of the legal questions before it. Figueroa was found guilty of 2 counts of aggravated child endangerment. The jury acquitted her of the involuntary manslaughter charge, a finding that indicated the jury did not find, beyond a reasonable doubt, that the endangerment was the direct legal cause of Serafina's death under the manslaughter standard. But the child endangerment conviction stood, and they stood firmly. Sentencing was held in Leavenworth County District Court in October of 2025. The court imposed a 12-month sentence, which was suspended in favor of probation. The sentence drew significant commentary from child advocacy organizations and legal observers in Kansas, many of whom noted that the suspended sentence, while within the court's discretion, reflected the fact that the jury had not convicted on the most serious charge. Figueroa's criminal record and the specific findings of the jury shaped the sentence the court was able to impose within Kansas sentencing guidelines. The case of Liberti Figueroa and Serafina is a case that sits at the intersection of child welfare law, parental responsibility, and the legal standards that Kansas courts apply when a very young child is harmed in the care of an inadequate caregiver chosen by a parent. It raises questions that child safety professionals throughout Leavenworth County and across Kansas continue to work through. Questions about how the law defines the duty of care, how courts quantify the harm of neglect, and how the criminal justice system responds when the circumstances of a child's death are severe, but the legal tools available for prosecution have limits. Serafina Figueroa was 18 months old. She was a baby. She needed someone to be paying attention, and on the day that mattered most, that attention was not there. The Leavenworth County courts found accountability in the form that the evidence and the law permitted. Child advocates in Kansas have continued to call for legislative attention to the gaps revealed by this case. Liberti Figueroa is serving her probation sentence. The case of Serafina remains part of the ongoing conversation in Kansas about what the law requires of parents and what communities can do to ensure the most vulnerable children never find themselves in the kind of danger that Serafina faced on that day in 2023. Do not forget to like this video and subscribe to Cold Case Hour. It truly makes a difference in helping us tell stories like Serafina's. Case 5, Tifany Adams, February 2026, Stevens County District Court, Kansas. There are cases where the facts, when laid out in sequence, seem almost too calculated and deliberate to be real. There are cases where investigators, reviewing the evidence and the timeline, find themselves looking not at an impulsive act committed in a moment of crisis, but at something that was planned, organized, and carried out with a cold and purposeful logic. The case of Tifany Adams, a case that began in the wide, flat farmland of Stevens County in the southwestern corner of Kansas and ended in a courtroom sentencing in February of 2026, is one of those cases. It begins, as so many of these cases do, with something that should have been resolved in a family law courtroom rather than a criminal one. A custody dispute. Children at the center of competing claims and competing loyalties. Adults who had once been part of the same family now positioned on opposite sides of a legal disagreement about who would raise the children they shared. Custody disputes are among the most emotionally charged legal proceedings that family courts encounter, and in the vast majority of cases, even the bitter and the prolonged, they are resolved through negotiation, mediation, judicial rulings, and, eventually, some form of workable arrangement. They are resolved without anyone being harmed. In Stevens County, Kansas, in the spring of 2024, that was not what happened. Veronica Butler and Jillian Kelly were on their way to a custody exchange on March 27, 2024. They were traveling through Stevens County, a county of fewer than 5,000 residents in the far southwestern corner of Kansas, where the landscape opens into the wide horizon of the high plains and the nearest major city is hours away. A custody exchange is a routine event in the lives of families navigating shared parenting arrangements. It is not supposed to be dangerous. It is not supposed to be anything other than a transition. Children moving from one car to another, from one household to another, under the legal framework that a family court has established. Veronica Butler and Jillian Kelly did not complete that journey. They were ambushed. They were confronted by individuals acting as part of an organized plan. They did not survive the encounter. Their remains were subsequently located by law enforcement, and the investigation that followed drew in not just Stevens County authorities, but state-level law enforcement resources as the scope of what had happened became clear. Tifany Adams was identified as a central figure in the orchestration of what the prosecution would characterize as a planned double homicide connected directly to the custody dispute. The investigation established that Adams had not acted alone. Other individuals were charged in connection with the case, but that she had been a primary architect of the plan that resulted in the deaths of Butler and Kelly. The charges against Adams in Stevens County District Court were the most serious that Kansas law permits, 2 counts of first-degree murder. The evidence assembled by prosecutors and law enforcement was extensive, and the case received significant national media attention, with coverage from the Associated Press, NBC News, and multiple major outlets noting the calculated nature of what had allegedly occurred. 2 women traveling to a routine custody exchange, targeted and attacked by people they knew through their family connections. The criminal proceedings moved through Stevens County District Court with the deliberate pace that first-degree murder cases require. Tifany Adams, following the conclusion of the evidentiary process, entered a plea of no contest to 2 counts of first-degree murder. As with the no contest plea in the Schroer case earlier in this documentary, the legal effect of this plea was the same as a guilty plea for purposes of sentencing. The court proceeded on the basis that the evidence supported the charges without requiring a full contested trial. Sentencing was held in February of 2026. Stevens County District Court imposed the sentence that Kansas law mandates for first-degree murder under these circumstances: life in prison without the possibility of parole. Tifany Adams will not be released. She will spend the remainder of her life in the Kansas Department of Corrections. There will be no parole hearing, no opportunity for release, no future in which she walks out of a prison as a free person. The sentence was final. It was appropriate to the crime. And it was, for the families of Veronica Butler and Jillian Kelly, a form of accountability, not the kind that restores what was taken, not the kind that answers the grief of children who lost people they loved because of a custody dispute that turned into something no family court ever anticipated. The impact of this case on Stevens County, a small, close-knit community of fewer than 5,000 people, cannot be overstated. In communities of that size, everyone is connected. The people involved in this case were not strangers to their neighbors. The children at the center of the custody dispute were known to schools, to churches, to the kinds of community institutions that make small towns function. When the news broke that 2 women had been targeted and ambushed on a Kansas road during a custody exchange, the shock that moved through Stevens County and beyond was not abstract. It was personal. It was the kind of shock that changes how a community understands itself and the people within it. Law enforcement officials and prosecutors in Stevens County spoke publicly about the significance of the verdict and the sentence. The message from the court was clear, that in Kansas, the use of violence as a tool in a family dispute, the deliberate targeting of individuals connected to a custody proceeding, would be met with the full force of the criminal justice system. Life without parole is the most severe sentence Kansas law permits for murder. Tifany Adams received it. For Veronica Butler and Jacqulyn Kelly, the sentence is a form of justice. Imperfect and incomplete in the way that all criminal justice is imperfect and incomplete when lives have been lost, but real and permanent and on the public record. Their names are part of that record now. Their stories are known. The circumstances of their passing and the accountability that followed are documented in the Stevens County District Court files and in the coverage of outlets that ensured the nation understood what had happened on a Kansas road in March of 2024. The children at the center of the custody dispute, the children whose lives Veronica Butler and Jacqulyn Kelly were traveling to protect and to serve when they were attacked, are part of this story's continuing chapter. Child welfare advocates and legal professionals who have followed this case have noted that the trauma of losing a parent or a caregiver to violence in the context of a custody dispute has profound and lasting effects on children. The systems that surround those children, schools, counselors, the family court itself, have responsibilities that extend well beyond the criminal verdict. Tifany Adams is serving her sentence of life without parole in the Kansas Department of Corrections. The case of Veronica Butler and Jacqulyn Kelly, their names, their lives, and the manner in which they lost their lives, will remain part of the public record of Stevens County, Kansas, and of the broader history of what can happen when a custody dispute becomes something catastrophic and irreversible. Justice, in this case, was delivered. It was delivered by the Stevens County District Court, by the prosecutors who assembled the evidence, by the law enforcement professionals who worked to bring this case to resolution, and by a Kansas legal system that did not flinch from imposing its most serious consequence when the facts demanded it. If you or someone you know is involved in a custody dispute that has escalated to threats or concerns about safety, please contact local law enforcement or reach out to the National Domestic Violence Hotline at 1-800-799-7233. No custody dispute is worth a life. No disagreement about children should ever become what this one became in Stevens County in the spring of 2024. Please like this video and subscribe to Cold Case Hour. Veronica Butler and Jacqulyn Kelly deserve to live. Sharing their story is one way we make sure they are not forgotten. Case 6. Adyson Burr, March 2026, Saline County District Court, Kansas. There are cases in any documentary of this kind where the full story has not yet been told, where the criminal justice system is still in motion, where the courts are still working through the procedural and evidentiary questions that stand between an arrest and a final verdict. These cases carry their own particular weight in the public consciousness because they sit in the space between allegation and adjudication, a space that the law treats with deliberate care and that responsible journalism must treat with equal care. The case involving Adyson Burr of Salina, Kansas, is one of those cases. It is a case that, as of the production of this documentary, has not reached its conclusion. No verdict has been returned. No sentence has been imposed. Under the foundational principles of the American legal system, Adyson Burr is presumed innocent of the charges filed against her until and unless a court of competent jurisdiction finds otherwise beyond a reasonable doubt. That presumption is not a technicality. It is the cornerstone of a justice system built on the principle that the power of the state to deprive a person of liberty must be constrained by rigorous standards of proof. With that foundation clearly established, here is what the public record shows. In January of 2026, emergency services were called to a residence in Salina, Kansas, the county seat of Saline County, a city of approximately 45,000 people situated in the geographic heart of the state. The call involved a 5-month-old infant, a baby boy. 5 months old is barely past the beginning of life outside the womb. A 5-month-old child is entirely, completely, and absolutely dependent on caregivers for every aspect of survival. This child did not survive what had occurred in that Salina residence. Law enforcement and medical professionals responded to the scene. The investigation that followed was conducted by the Salina Police Department and the Saline County Sheriff's Office in coordination with the Saline County District Attorney's Office. The investigation examined the circumstances surrounding the infant's death, the conditions in the home, and the timeline of events leading up to the emergency call. In March of 2026, Adyson Burr was charged in Saline County District Court with first-degree murder and child abuse in connection with the January 2026 death of her 5-month-old son. These are, under Kansas law, the most serious charges that can be brought in a case involving harm to a child. First-degree murder requires the prosecution to prove, beyond a reasonable doubt, that the defendant caused the death of another person deliberately and with premeditation. Following her arrest, the court system moved through the procedural stages that serious criminal cases require. A critical early step in any felony case involving a defendant's capacity to participate in their own defense is a competency evaluation, an assessment by qualified mental health professionals of whether the defendant understands the nature of the charges against them and can meaningfully participate in the legal proceedings. In the Burr case, that evaluation was conducted, and in the early months of 2026, the Saline County District Court made a finding that Adyson Burr is competent to stand trial. That finding clears the way for the case to proceed to its next stages. As of the production of this documentary, further court proceedings are scheduled in Saline County District Court for May of 2026. Those proceedings will move the case through the pretrial process, motions, evidence review, and the scheduling framework that leads toward a trial date. The 5-month-old boy at the center of this case, a baby who had been alive for only 5 months, who had not yet had the chance to learn to sit up on his own or discover the names of things or know the world beyond the small radius of a Salina home, deserves to be acknowledged in this space with the care and the dignity that all victims deserve, regardless of the stage of the legal proceedings surrounding their case. His story is not finished being told. The Saline County courts will tell more of it in the months ahead. Responsible journalism and responsible documentary storytelling requires us to hold two things simultaneously in cases like this: the gravity of what is alleged and the importance of the legal presumption that no one is guilty until proven so in a court of law. Both of these things are true at the same time, and both of them matter. What is not in dispute is that a 5-month-old child lost his life in Salina, Kansas in January of 2026. What is not in dispute is that a mother has been charged in connection with that loss, that a court has found her competent to stand trial, and that the Saline County District Court will be the institution responsible for hearing the evidence and determining what happened and what accountability, if any, follows. The families and community members of Salina who have been affected by this case will continue to watch the proceedings with the kind of attention that cases involving the very youngest victims always generate. The Salina community, like communities across Kansas, understands that the criminal justice system is designed to answer the hardest questions, not quickly, not simply, but thoroughly, and with the weight of evidence and law behind every finding. We will continue to follow this case on Cold Case Hour as it develops. What has happened in Saline County is not something the community will forget, and it is not something that responsible true crime journalism can set aside simply because the courts have not yet reached their final conclusion. If this case raises concerns for you about the safety of infants and young children in your community, the Child Help National Child Abuse Hotline remains available around the clock at 1-800-422-4453. The youngest children among us are the most vulnerable. The systems and communities that surround them are their only protection. Do not forget to like this video and subscribe to Cold Case Hour. Every subscription helps us continue telling these stories with the seriousness and the care they deserve. Case 7. Jacqulyn Kirkpatrick 2021 Wyandotte County District Court, Kansas. Kansas City, Kansas sits on the western bank of the Missouri River, directly across from its larger Missouri namesake. It is a city of neighborhoods, some struggling, some resilient, many both, where community bonds are deep and the loss of a child is felt with a particular and lasting intensity. Wyandotte County, which encompasses Kansas City, Kansas, has seen its share of difficult criminal cases pass through its district court. But even in a court system with experience handling serious crimes, the case of 6-year-old Olivia Jansen stood out. Not because the legal questions were unusually complex, but because of who Olivia was, how young she was, and the fact that her body was found in a shallow grave. Olivia Jansen was 6 years old in 2020. 6 years old is first grade or the approach to it. A child who is just beginning to navigate the structured world of school and friendships, and the growing awareness of the larger world beyond the family home. 6-year-olds still believe that the adults responsible for their care are fundamentally trustworthy. They have not yet developed the capacity to fully recognize, assess, or respond to danger in the way that older children and adults can. Olivia Jansen was 6. She was in someone's care, and she did not survive it. Jacqulyn Kirkpatrick was the maternal figure in Olivia's life, the adult who occupied the role of caregiver and who was responsible for the child's safety and well-being. The exact nature of the relationship and the specific events that led to Olivia's death in 2020 were established through the investigation conducted by the Kansas City, Kansas Police Department and the subsequent prosecution in Wyandotte County District Court. What the investigation found, and what the prosecution established as the factual basis for the charges, is part of the public record. Olivia's body was discovered. She had been placed in a shallow grave. The manner of her discovery, the fact that there had been an attempt to conceal her remains, was itself a significant factor in the investigation and in the understanding of what had occurred. When a child's body is hidden, it speaks to awareness, on the part of whoever hid it, that what had happened was wrong and would be treated as a serious crime by law enforcement. The concealment did not succeed. Law enforcement found Olivia, and the investigation that followed moved with the seriousness that the discovery of a 6-year-old child in a shallow grave demands. Jacqulyn Kirkpatrick was identified, investigated, charged, and brought before Wyandotte County District Court. The charges against her, second-degree murder and child abuse, reflected the evidence that prosecutors had assembled. Second-degree murder under Kansas law, unlike first-degree murder, does not require proof of premeditation. It requires proof that the defendant intentionally caused the death of another person, or caused it under circumstances that demonstrated an extreme indifference to the value of human life. The prosecution's theory of the case, and the evidence supporting it, led Kirkpatrick and her legal team to a decision that avoided trial. Jacqulyn Kirkpatrick pleaded guilty to second-degree murder and child abuse in Wyandotte County District Court. The guilty plea was an acknowledgement, in the most legally significant form available, of her responsibility for what had happened to Olivia Jansen. It was an acknowledgement that the 6-year-old child in her care had not survived, that the cause of that outcome was connected to Kirkpatrick's actions, and that the charges the state had brought against her were ones she could not in good conscience or good legal strategy contest. Sentencing in Wyandotte County District Court in late 2021 resulted in a term of 31 years in the Kansas Department of Corrections. 31 years is a substantial sentence, one that reflects the court's assessment of the gravity of what had been done to a 6-year-old child and the additional aggravating factor of the concealment of her remains. Kirkpatrick will not be eligible for release consideration for a significant portion of that term, and even when eligibility arises, the parole system will have the full record of this case before it. The Wyandotte County community's response to the sentencing was one of grief, relief, and the particular kind of exhausted resolution that families and community members feel when a legal process reaches its conclusion without restoring what was lost. Olivia Jansen was gone. No sentence could change that. No verdict could return the 6-year-old girl who had been in someone's care and had not come home. What the verdict and the sentence could do, and what they did, was place accountability on the public record and give the community the knowledge that the courts had answered. Olivia Jansen was 6 years old. She was found in a shallow grave, which means her story did not end gently or with dignity at the moment of her passing. But it ended with her name spoken in a courtroom, with the weight of the law brought to bear on behalf of her life, and with a 31-year sentence imposed in her name in Wyandotte County District Court. Child welfare professionals who have reviewed this case have noted the importance of community awareness and the reporting systems that allow concerned neighbors, teachers, and family members to flag children who may be in unsafe circumstances. In Wyandotte County and across Kansas, the systems for reporting concerns about child safety exist precisely to prevent children from reaching the point that Olivia reached. If you see something, if something about a child's circumstances does not feel right, if the questions you have about a child's welfare are not being answered, please contact the Kansas Protection Report Center at 1-800-922-5330. Olivia deserved better. The Wyandotte County courts ensured that the person responsible for her safety and for her death was held accountable under Kansas law. Please like this video and subscribe to Cold Case Hour. We tell these stories so that children like Olivia are never just a statistic, so that their names are known and their lives are honored. Case 8. Debora Green, March 3, 1996, Johnson County District Court, Kansas. There are cases in the history of Kansas criminal justice that have transcended the boundaries of local and state attention and entered the national consciousness. Cases that were covered not just by Kansas newspapers and regional television stations, but by the major national networks, by true crime authors, by documentary filmmakers, and by the kind of sustained journalistic attention that marks a story as something the country needed to understand. The case of Debora Green is one of those cases. It is a case that shook Johnson County, one of the most affluent counties in Kansas, a suburban landscape of manicured streets and professional households south of Kansas City, to its foundation. And it is a case that, more than 30 years after the events it describes, remains one of the most documented and analyzed criminal cases in Kansas history. To understand the case of Debora Green, it is necessary to begin with who she appeared to be. Debora Green was a physician. She had completed medical school, had practiced medicine, and had reached a stage of professional and personal life that, from the outside, represented exactly the kind of achievement that Prairie Village, the upscale Johnson County community where her family lived, celebrated, and valued. She was married to Dr. Michael Farrar, also a physician. They had 3 children together, Kate, Tim, and Kelly. They lived in a large, comfortable home in Prairie Village. They were, by any external measure, a successful American family. Behind that exterior, the marriage of Debora Green and Michael Farrar had deteriorated significantly. The relationship had become deeply troubled, marked by conflict, separation attempts, and the kind of sustained interpersonal fracture that can, in some cases, become dangerous. What Green did with the anger and the desperation of that deteriorating marriage would ultimately claim the lives of 2 of her children and come very close to claiming the life of her husband. The first element of this case involves what happened to Michael Farrar in the months before the fire. Dr. Farrar began experiencing episodes of severe illness, nausea, weakness, symptoms that did not follow an obvious medical pattern and that his colleagues found difficult to explain. As a physician himself, Farrar knew that something was wrong. What he did not initially know was that his wife, also a physician, with the knowledge of pharmacology that her training had given her, was responsible for his declining health. Investigators and prosecutors later established that Debora Green had been introducing ricin into Farrar's food. Ricin is a highly toxic compound derived from castor beans, a substance that medical and forensic professionals describe as extraordinarily dangerous in even small quantities. Green was poisoning her husband, slowly, with a physician's knowledge of what the substance would do and how it would present. Farrar survived, in part because the dosing was inconsistent and in part because he eventually removed himself from the household environment as his health deteriorated. The fire came on the night of October 24, 1995. The Green family home in Prairie Village was a large, 2-story structure in a quiet residential neighborhood. On that October night, a fire broke out in the home. 2 of the children, Kate Green, 13 years old, and Tim Green, 11 years old, did not escape. They lost their lives in the fire. The youngest child, Kelly, survived, as did Debora Green herself. The investigation that followed was conducted by Johnson County law enforcement in coordination with fire investigators and forensic specialists. The questions that investigators needed to answer were fundamental. What had caused the fire? Where had it started? And were the circumstances consistent with an accidental origin or with something else entirely? Fire investigation is a highly specialized forensic discipline, and the professionals who examined the Green home applied that discipline to the evidence the fire had left behind. The conclusions they reached were not consistent with accident. The fire's origin and burn patterns, the distribution of accelerant evidence, and the totality of the investigative picture pointed toward a deliberately set fire rather than an accidental one. The investigation also proceeded in the context of what had been happening to Michael Farrar, the months of unexplained illness, the subsequent identification of ricin as the cause, and the picture of a marriage in which one party had already demonstrated a willingness to use poison as a tool of harm. Debora Green was arrested and charged in Johnson County District Court. The charges against her were among the most serious available under Kansas law: first-degree murder for the deaths of Kate and Tim, and arson for the deliberate setting of the fire that killed them. The investigation had also established the poisoning of Michael Farrar, and those charges were incorporated into the legal proceedings. The case proceeded through the Johnson County courts in the mid-1990s with significant public attention. On March 3, 1996, Debora Green entered a plea of no contest to the charges, including first-degree murder and arson, in Johnson County District Court. The no contest plea, as in other cases in this documentary, carried the same legal weight as a guilty plea for sentencing purposes. Johnson County District Court sentenced Debora Green to 2 concurrent life terms, life in prison for the first-degree murder convictions, to be served at the same time. The sentence was appropriate to the magnitude of what had occurred, the deliberate taking of 2 children's lives, combined with the months-long poisoning of a husband who had barely survived. The case of Debora Green became, in the years that followed, one of the most extensively documented criminal cases in Kansas history. The true crime author and Rule wrote a detailed account of the case in her book, Bitter Harvest, published in 1997, which brought the story to a national readership. The book documented the investigation, the marriage, the medical details of the ricin poisoning, and the fire that took Kate and Tim Green's lives with the kind of thorough journalistic attention that Rule was known for throughout her career. The book remains in print and remains one of the most widely read accounts of a Kansas criminal case ever produced. Kate Green was 13 years old. Tim Green was 11 years old. They lost their lives in a fire in their own home in Prairie Village, Kansas on October 24, 1995. They were children asleep in their beds, in the place that is supposed to be the safest place in any child's world. They did not wake up. The Johnson County courts, in their sentence of March 1996, made certain that the accountability for their deaths was recorded and enforced. Debora Green has been serving her concurrent life sentences in the Kansas Department of Corrections since that sentencing. She has appeared before the parole board in subsequent years, and as of the documented record available, remains incarcerated. The case of Debora Green is taught in law schools and studied in forensic science programs as an example of the intersection of medical knowledge, domestic conflict, and criminal behavior. It is a case that Prairie Village, Johnson County, and the state of Kansas have not forgotten, and should not forget, because the lives it claimed were real, the children who lost their lives were real, and the accountability imposed by the Johnson County District Court was the justice that Kate and Tim deserved. Please like this video and subscribe to Cold Case Hour. Cases like this one, cases that shaped the history of Kansas and of American true crime documentation, deserve to be told with the seriousness and the care that the lives at their center demand. Case 9. Rachael Hilyard, April 5, 2017 through August 2022, Sedgwick County District Court, Kansas. Wichita is the largest city in Kansas, a city of nearly 400,000 people, the economic and cultural center of the south-central part of the state, home to a major aviation industry, a diverse population, and a law enforcement and court system that handles one of the highest volumes of serious criminal cases in the state. The Sedgwick County District Court has seen extraordinary cases move through its chambers over the decades. But even in Wichita, even in a city with deep familiarity with the full range of human behavior, the events of April 5, 2017 produced a response from investigators, prosecutors, and the community that was visceral and lasting. Mickey Davis was a woman in her later years, living in Wichita, going about her life in the way that people in her circumstances do. She was not a public figure. She was not a person whose name was widely known in Sedgwick County before April of 2017. She was someone's mother, specifically, the mother of a man who had been in a romantic relationship with Rachael Hilyard. That connection, the fact that Mickey Davis was the mother of Rachael Hilyard's former partner, is the thread that ties her, in the most terrible way, to the events of that April day. Rachael Hilyard and Mickey Davis were known to each other through the relationship between Hilyard and Davis's son. Whatever the dynamics of that extended family relationship, whatever tensions, grievances, or conflicts existed between Hilyard and the family of her former partner, the record shows that those tensions reached a point of catastrophic violence on April 5, 2017. Mickey Davis was attacked. The severity of what happened to her, documented in the forensic record and presented as evidence in the subsequent criminal proceedings in Sedgwick County District Court, went far beyond what most criminal cases involving personal violence entail. Mickey Davis did not survive the assault, and the manner of her death, as established through the forensic investigation and the court proceedings, included evidence of extreme violence that shocked the investigators and forensic professionals who documented it, and that was described in court proceedings in terms that the legal system, the community, and the media treated with the gravity it demanded. Rachael Hilyard was identified, investigated, and charged in Sedgwick County District Court with the first-degree murder of Mickey Davis. The investigation conducted by the Wichita Police Department and Sedgwick County prosecutors was thorough, and the evidence assembled connected Hilyard to the crime scene and to the events of April 5, 2017 in a manner that the court and ultimately the appellate system found sufficient to support conviction. The trial and conviction in Sedgwick County resulted in a sentence that reflected the extreme nature of what had occurred. A hard 50 sentence under Kansas law. A hard 50 sentence means that the defendant is sentenced to life in prison and is not eligible for parole consideration until they have served a minimum of 50 years. 50 years. It is, short of the death penalty, the most severe sentence that Kansas law provides for a non-capital murder conviction. The imposition of a hard 50 sentence signals that the court found the circumstances of the crime to be among the most aggravated, that the nature of what occurred, and the manner in which it occurred, placed this case at the extreme end of the spectrum of severity that Kansas sentencing law recognizes. Hilyard appealed her conviction and her sentence, as defendants in serious criminal cases have the right to do under the American justice system. The appeal was considered by the Kansas Supreme Court, the highest court in the state, which reviewed the legal questions raised by the defense with the thoroughness that Supreme Court review requires. In August of 2022, the Kansas Supreme Court issued its ruling. The conviction was upheld. The hard 50 sentence was upheld. The Kansas Supreme Court, having examined the record and the legal arguments, found no basis to disturb either the verdict of the trial court or the sentence imposed. The finality of a Kansas Supreme Court ruling, when it affirms a conviction and sentence, is significant. It means that the state's highest judicial authority has reviewed the case, examined the evidence and the legal arguments, and determined that the criminal justice process was properly conducted and that the outcome was legally sound. For Rachael Hilyard, the August 2022 ruling meant that the path of appeal had run its course at the state level. The conviction stands. The hard 50 sentence stands. Mickey Davis was someone's mother. She was someone's neighbor, someone's friend, someone who had lived her life in Wichita and who had not, in any meaningful sense, asked for what came to her door in April of 2017. She deserved to live out the rest of her life in peace. She deserved to be safe. The Sedgwick County courts, and ultimately the Kansas Supreme Court, ensured that what happened to her was answered with the full force that Kansas law provides. Rachael Hilyard is serving her hard 50 sentence in the Kansas Department of Corrections. She will not be eligible for parole consideration until she has served 50 years. The decision of the Kansas Supreme Court in August of 2022 closed the appellate chapter of this case and affirmed that the accountability imposed by Sedgwick County's courts was correct, was appropriate, and would stand. For families navigating difficult or dangerous relationship dynamics, situations where conflict has escalated to a point that feels threatening or unsafe, the National Domestic Violence Hotline at 1-800-799-7233 provides confidential support and safety planning 24 hours a day, 7 days a week. No conflict, however deeply felt, has to end the way this one ended in Wichita in 2017. Please like this video and subscribe to Cold Case Hour. Mickey Davis deserved safety and peace. Sharing her story is the least we can do to ensure her name is remembered. Case 10. Lindsey Nicole Blansett 2014 through 2015 Sumner County District Court, Kansas. Wellington, Kansas is the county seat of Sumner County, a quiet agricultural community of approximately 7,000 residents situated in the south-central part of the state, not far from the Oklahoma border. It is the kind of small Kansas city where the rhythms of life are predictable and familiar, where community members know their neighbors, and where the institutions of local government, the schools, the churches, the law enforcement agencies, the courts, are woven into the daily fabric of existence in a way that larger cities rarely achieve. Wellington is not accustomed to the kind of attention that serious criminal cases bring. It does not expect to find itself at the center of a story that will be covered by statewide media and discussed by legal professionals and mental health experts across Kansas. The case of Lindsey Nicole Blansett and the death of her son, 10-year-old Caleb Blansett, brought that attention to Wellington in 2014 and kept it there through the criminal proceedings that concluded in 2015. It is a case unlike most others in this documentary, not because the outcome was any less tragic, and not because the legal accountability was any less serious, but because the circumstances that surrounded it raised questions about the intersection of mental illness, parental love distorted beyond recognition, and the criminal justice system's responsibility to hold individuals accountable even when the motivations behind their actions are deeply disturbed. Caleb Blansett was 10 years old in 2014. 10 is a particular age in childhood, old enough to have a developed personality, to have favorite things, to have friendships and opinions, and the beginning of a relationship with the wider world. 10-year-olds are aware of their families, of their circumstances, of the emotions of the people around them. They are not adults, and they are not toddlers. They are children in the fullest sense, present, engaged, capable of love and of fear and of everything in between. Lindsey Nicole Blansett was Caleb's mother. She was his primary caregiver. She was the person whose responsibility for his safety and well-being was, under both the law and the most basic human understanding of parental duty, absolute and non-negotiable. What happened in Wellington in 2014 was shaped, according to the evidence and the mental health evaluations that formed part of the legal proceedings, by a profound disturbance in Lindsey Blansett's perception of reality. The evidence presented at trial in Sumner County District Court established that Blansett had developed a fixed and intense belief, a belief that investigators, prosecutors, and mental health professionals working with the court characterized as delusional, that an apocalyptic event was imminent, that the world, as she understood it, was coming to a catastrophic end, that the suffering that would accompany that end would be terrible and inescapable. And within that distorted framework, within the logic of a mind that had lost its connection to shared reality, Blansett reached a conclusion about her son that no functioning cognition would ever reach. She concluded that by causing Caleb's death herself, she would be sparing him from the suffering of the apocalypse she believed was coming. That she was, in the framework of her delusion, acting out of love. That this was protection. The law does not accept that framework as a defense to murder. The Kansas criminal justice system, like criminal justice systems across the country, operates on the principle that the consequences of harmful acts must be answered for, and that the presence of mental disturbance, while relevant to the proceedings and to sentencing considerations, does not automatically negate criminal responsibility. The question of criminal responsibility in cases involving mental illness is one of the most complex and contested areas of criminal law, and Sumner County District Court had to navigate it carefully. On a day in 2014, Lindsey Nicole Blansett fatally stabbed her 10-year-old son Caleb in their Wellington home. Emergency services responded. The investigation that followed was conducted by Wellington law enforcement and Sumner County prosecutors, who documented the crime scene, assessed the evidence, and developed the case that would be presented in Sumner County District Court. Blansett was charged with first-degree murder. The charge carried the most serious consequences Kansas law provides. The legal proceedings addressed, among other things, the question of Blansett's mental state, the evaluations that were conducted, the expert testimony that was presented, and the ultimate legal determination that the court was required to make about whether the evidence supported conviction under Kansas's first-degree murder statute. The jury in Sumner County returned a verdict of guilty on the charge of first-degree murder. The finding was that Lindsey Nicole Blansett had committed first-degree murder in the death of Caleb Blansett, her son, in Wellington, Kansas in 2014. Whatever the distortions of perception that had accompanied the act, the legal accountability was clear. Sentencing in Sumner County District Court in 2015 resulted in a sentence of life in prison under Kansas's Hard 25 provision, meaning that Lindsey Nicole Blansett would not be eligible for parole consideration until she had served a minimum of 25 years. It is a sentence that reflects the severity of the crime, the deliberate act of a parent against a child, even as the circumstances surrounding it have prompted ongoing discussion among mental health professionals, legal scholars, and child welfare advocates about how the criminal justice system should respond when the boundaries between illness and accountability become difficult to locate. Caleb Blansett was 10 years old. He had a life ahead of him, friendships, growth, discovery, the unfolding of whatever he would become. He did not have the chance to become it. And the manner of his death, at the hands of the person who was supposed to protect him most, in the name of a delusion that had no connection to reality, is one of the most heartbreaking facts in Sumner County's history. The case of Lindsey Nicole Blansett is also, in the mental health and criminal justice communities, a case that has contributed to ongoing conversations about the identification and treatment of severe mental illness in parents, and about the systems, medical, social, community-based, that might intervene before a parent's distorted perception of reality reaches the point that Blansett's did in Wellington in 2014. Those conversations are not comfortable. They require communities to ask hard questions about who is responsible for ensuring that parents who are struggling with their mental health receive the support and intervention they need before tragedy occurs. The National Alliance on Mental Illness Helpline is available at 1-800-950-6264 for individuals and families navigating mental health challenges. Early intervention, access to treatment, and community support structures are not just humane, they can be life-saving. Lindsey Nicole Blansett is serving her life sentence in the Kansas Department of Corrections under the Hard 25 provision. Caleb Blansett was 10 years old. His name belongs on the public record of Sumner County, Kansas, spoken with the care and the respect that a child's life, however short, deserves. Please like this video and subscribe to Cold Case Hour. Caleb deserved to grow up. Telling his story with honesty and care is how we make sure the world knows what happened in Wellington, Kansas, and why accountability, in all its complex and imperfect forms, matters.